Okay. Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, arbitration, collaborative law, restorative justice, ombuds, adjudication, negotiation, conciliation, and early neutral evaluation. My name is DrChinweEgbunike, a postdoctoral fellow at the University of Brighton, United Kingdom, and the fellow of the American Bar Association section of Dispute Resolution. I am excited to welcome Ana Luiza Etchalus to the EVA show. She is a co-founder of OLADC-Latin American Organization of Collaborative Law, a member of the board of directors of the Global Collaborative Law Council USA. Ana is a mediator and arbitrator, a mentor for Canadian companies in Brazil and the Canadian government mentoring program. She is associated with the Spanish Chamber of Commerce in Brazil. Ana wears many hats, so I've left the link to her profile below. Welcome to the show, Ana. Let me stop sharing my screen now. It's such a pleasure having you. Thank you so very much for honoring the invitation.
Thank you, Chewy, or Chichi. It's a pleasure for me to be here. Sorry if I change it. My accent is it's a bit a tropical accent, but I'm so happy to be here. I'm honored to be here, actually. And I mentioned when we met for the first time that it will be super excited. It will be a pleasure for me to spread something, a message or a tip to Africa. And I'm so happy here.
Yeah, thank you so very much. So without further ado, the first question is, what is collaborative law and its impact in Brazil?
Well, collaborative law is a contractual and extrajudicial conflict resolution methodology through which the parties and their lawyers collaborate with each other to reach an agreement. Negotiating in a confidential, transparent manner and without the threat of litigation, as the lawyers are expressly committed in this contract not to serve the same clients in a dispute if the result of the collaborative process does not reach an agreement. The objective of the collaborative process, it is the agreement. And this methodology was created by North American lawyer Stu Webb, a family lawyer who decided to work in a non-adversarial way and conceived the methodology. Initially, it had spread in family law and later began to be used in other areas such as commercial, civil, and labor issues. And in the United States, there's a law, a real law, the Uniform Collaborative Law Act, which has already been adopted by more or less 24 confederate states. In Brazil, we do not have a law, and collaborative, despite of the name collaborative law, we don't have a law, but it can be applied as a methodology, structured negotiation worked within a private contract. But even without a law, we keep naming as collaborative law because we have some differences in terms of translation. So, and how can I say, related to Brazil is a continental country. It is a very large and with great cultural differences from north to south, and collaborative law in Brazil, it is still not very widespread, and the vast majority of lawyers do not know or confuse it with mediation. So personally, I belong to, like you mentioned, I belong to a Latin American group, OLADC, the Latin American Collaborative Law organization that already has lawyers representing 11 countries in the region.
Wow.
And this has encouraged lawyers in each country to better organize themselves to reach a greater number of practitioners. Also the fact that I am in the board of GCLC allows for a great interface with all these groups in a more inclusive and truly, I hope, collaborative way.
Right. So is there likely that a new law from Brazil on collaborative law would be enacted soon?
Could you please repeat?
I said, will there be sort of in future or in the nearest future law on collaborative law? How soon would it be enacted under the Brazilian law?
Well, I like the idea. It is my personal opinion. I like the idea of a methodology, not exactly a law, because we already have a lot of formal rules, and I think this methodology is innovative.
Okay.
So if we put it on a rule, we are going to lock it in a very traditional way. So that it is my opinion. Okay. But in Brazil, we have a small history, but we started talking about collaborative around 2014. With the creation of the IBPC, Brazilian Institute of Collaborative Practices. It was brought from related to family law and with a non-exclusive vision for lawyers under the name of collaborative practices. This concept also talks about a collaborative methodology, but with some differences. It focuses on family law and states that conflicts should be resolved by a multidisciplinary group of professionals. In other words, a group of professionals from different expertise with specialization in conflict resolution to resolve a conflict. This, Chichi, ended up causing collaborativity to be seen exclusively as a methodology where collaboration would occur between the group of professionals and not between lawyers from parties that were in conflict. And I think it's a very important point out this difference so that lawyers can get closer the methodology. For example, more recently, these differences have begun to be brought to light and more lawyers are beginning to become interested in the methodology as a possible working tool in resolving conflicts outside the legal system. But as you can see, I talk a lot. Interesting thing to say here is that collaborative law allows the occasional participation of professionals with expertise other than a lawyer, as long as necessary to help clarify the parties on specific technical issues, for example, financial neutral or a psychologist or an engineer. Let's think about litigation. In a litigation, the process admits technical evidence so that the judge can judge a case. In the collaborative process, other professionals are also admitted, but if the parties so wish, because we are dealing with a methodology based on the free and informed autonomy of the will of the parties.
Parties, okay. Okay.
So if the parties, it's the parties who decided. And this is also my opinion, as the reality in Brazil is a country with a very low average per capita income.
Okay.
It will be impossible for the vast majority of the citizens, for example, to adopt this collaborative practice as professed so far, as people don't have money to pay all the professionals involved, which would limit the methodology to only a wealth group. So in the version defended by Global Collaborative Law Council, collaborative law is understood as a tool for lawyers to help their clients reach a consensual solutions, whether or not use the assistance of other professionals during negotiations.
Oh, thank you so very much, Anna. You've touched on the history of collaborative law, and also, yes, I think I would have to ask you about access to justice. Has ADR enhanced access to justice in Brazil? I'm quite curious, not necessarily collaborative law, but just ADR generally,
Okay, the main methodology, or the most famous in Brazil, is ADR, is mediation. Also. One of the ADRs, more the star. Mediation started, as we know now, in Brazil, based on an initiative that the courts started. Our main council in that regulates the courts made a regulation applying intrajudicial mediation in all over our courts. It was 2010. And after that, in 2015, we had a new procedural code, and at the same time, we had, for the first time, a federal mediation rule. So. And now mediation is recognized as in intra-litigation and in the private world as well.
Okay. Oh, thank you so very much. So how about arbitration? Is it well developed as well?
Yeah, not much, but I'm able to do that. Sometimes I did, but nowadays I deal with consensual methodologies, not adversarial methodologies. And arbitration is older in our legal system than mediation. But it is still expensive. It's very expensive. And normally only big companies deal with mediation, with arbitration.
Okay, that's all right. So I was about asking, thank you so very much, about the cost and time frame. If there's any measurable difference or impact on the cost and time frame for settling disputes under collaborative law compared to litigation and mediation.
Well, you mean there is both mediation and collaborative law are part of the ADRs, and naturally help citizens and companies to resolve conflicts more quickly and cheaply. This is the purpose. With regard to collaborative law, the process is contracted and customize it by the parties themselves and the
Mhm.
lawyers,
Mhm.
which means that the parties have the power to decide how long the process that aims to reach the agreement will last.
Okay.
And,
Yeah.
but it is still difficult to talk about numbers because confidentiality as
Yeah.
part of the methodology does
Yeah.
not allow for many statistics. So
Okay. Okay. So when it comes to cost, you can't really tell how much
well,
it's
yeah,
cheaper
it
than mediation or
for
vice
example,
versa.
yeah, we don't mediation in Brazil. In private mediation, it depends on the professional, the mediator, the private mediator,
Okay.
how much. There's no regulation. There's some suggestions, for example, for lawyers who work as lawyers and as mediators, but there's no obligation. It is free. It depends on the market. In the courts, the mediation depends. The cost depends on the cost of the process, and it is difficult to precise.
Okay. All right.
And collaborative law tends to be less expensive because, for example, the cost when you have to go to the court, you have to pay a tax amount of money.
Yeah.
And this money depends on how much it will cost your case. And it is proportional.
Yeah.
But we don't have this cost in collaborative law, for example.
Okay.
Yeah.
All right, thank you so very much. So I think you've touched on the differences and similarities between mediation and collaborative law.
Yeah.
Did we
You
still,
asked me.
yeah, do you want to say something more on that, or should
No,
we?
this is nice because
Okay.
because it is a good opportunity to clarify, because lawyers
Yeah,
are all the time confusing the methodologies.
you're right.
And I think the similarities exist at the heart of both methodologies. That is, both mediation and collaborative law are methodologies that work with confidentiality. They are voluntary, that is, no one is obliged to be in mediation or to remain in a collaborative process.
Yeah.
And the fundamental difference is that in mediation, we have a third party who is the mediator, a neutral figure who seeks to restore communication between the parties until they can eventually reach an agreement. In collaborative law, we are talking about lawyers, each one assisting their own client without the necessary presence of a neutral third party. And these lawyers are contractually committed to working towards reaching an agreement. That is, mediation's main objective is to restore communication between the parties so that they can try to reach a solution. But collaborative law, the main objective is to reach the agreement. The goal is agreement. I don't know if it's enough.
Yeah, it is enough. All right, thank you so very much on that. So I think the models, yes, okay, so what are the models that can be used in collaborative law?
As I explained it above, there are some versions. For example, the so-called collaborative practices, which understand that the methodology would necessarily be applied by a group of professionals with a different expertise who collaborate with each other. And there is a collaborative law itself, a methodology aimed at lawyers working collaboratively, even though they are adversaries, as they commit to trying to reach an agreement. This does not mean, I repeat, that they cannot avail themselves of the help of other professionals, but as long as it is necessary and if the parties agree and have the money to pay it. But basically, what is expected of these lawyers is that they have similar tools to mediators. For example, work with non-violent communication, active listening, know various negotiation techniques, know about style of conflicts, be creative, and avoid conflictive approach, among other things.
Yeah. So, thank you so very much. Could you say that in collaborative law, can it be facilitative? You know, the approach when settling disputes, can it be facilitative or directive?
I think depends on the lawyer's style. Yeah, depend on the lawyer's style, the nature of the conflict. For example, in a family issue, must be more facilitative, more soft, but in a trade conflict, for example, more objective.
Okay, thank you so very much. So I think we're running out of time. So what are the pros and cons of collaborative law?
We cannot apply collaborative law to all issues, but to those that can be subject to negotiation, as is the case with private rights, for example. The pros are the possibility of resolving conflicts in less time and also in a way that suits the characteristics of the citizens or companies involved in the conflict, as well as the costs that are more appropriate to each person's economic capacity. But not all subjects and rights are capable of being in collaborative process, which is why it is important for the lawyer to have exact knowledge of the tool to know how to apply it. I wouldn't know how to talk about the cons other than to highlight that lawyers who work with this methodology must be very committed to high ethical standards.
Okay, thank you so very much. So there is no disadvantage. Yeah, that's great to hear. Okay.
Thank you.
So what can collaborative law be utilized in all states or cities in Brazil?
Well, Brazil is a country that lives in a federation system. That is, all norms called public order apply without distinction to all states of the federation, such as civil rules or even procedural rules. For now, we do not have a collaborative law, but the methodology can be applied as a structured negotiation model built through a private contract. Any damage that could be caused by the misuse of this tool ends up in the field of civil liability.
Interesting. Wow. Okay, thank you so very much. So what is your advice for mass advocacy of ADR?
Well, I have so many advice. But in less than 30 years, we will be 10 billion people in the world. We will have more shortage of many things: water, food, housing, work. How we are going to solve this? Exterminating each other? No, we must find balanced and sustainable solutions. And this can be done through, for example, extrajudicial solutions, as in this case, collaborative law or mediation. these methodologies allow us to respect the characteristics of each person and their needs. And my advice is to do what you are doing here, for example, speaking and bringing important messages to people. More and more citizens and companies need to know about the possibility of resolving their conflicts appropriately and always maintaining their own decisions-making power.
Oh, thank you so very much. I think this is also sort of, I think you've answered that question, but let me still ask it. What is the future of international legal research and podcasting, particularly in ADR? Yeah.
So this initiative of yours is an example that teaching nowadays has also changed.
Yes.
Thanks to technology, knowledge can reach more and more people in the world and in a simplified way. I congratulate you on this initiative, and I'm very honored to participate, especially because I know I can reach a lot of people in Africa.
Yeah.
I remember mentioning to you in the first time we met that Brazil has a great connection with Africa. We have many people of African descent, and we have a lot of influence from African culture in our country. Religion, music, food, and also many words in Portuguese and names that were adopted by African influence. It must be said that Brazil owns a lot to Africa, and I would like to once again thank you for this opportunity.
Oh, thank you so much, and you're so humble. I'm so glad that you agreed to, come on the show to speak about what you love, what you're passionate about as well, which is collaborative law, ADR in general. So thank you so very much. I think I have one more question. So what are the aims and objectives? Oh, I'm running out of time. You just told, I've just been given a formal warning probably. So what are the aims and objectives of Etchalus?
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 Okay, Etchalus law firm.
Law firm,
my goals with my legal studio are to prevent and resolve conflicts for my clients. I've been in this business for such a long time, Chichi. So I want to
Is it 40 something years now? Is it 40?
Oh, I'm sorry?
Is it 40 something years you've been in practice?
Awesome. So I started when I was 20 years. I was 20 years old. So my goals is to prevent. I'm working with prevention. I'm building relational contracts which is something that I like a lot. Applying collaborative approach in building relationships and to offer to my clients a more simplified and comfortable way for them, helping them reach solutions that bring them satisfaction and a better quality of life in their projects. I'm very happy to have expanded my skills as a lawyer, and I hope to improve even further.
Oh, thank you so very much, Anna. Thank you so very much. I can't stop saying thank you. I appreciate it.
Thank you, because we need to take a picture together.
Oh, Anna.
Yeah, of course.
Should we do it now? Okay. How do we do it? Oh my.
Just just a minute. Let's see.
Okay, you can use your
Okay. Oh, so beautiful. You look nice. Thank you so much.
Thank you so much for coming on the show. And I appreciate your insights, perspectives, and the learning you've shared with us. And I believe that potential users would embrace all you have stated herein. And, go for ADR, particularly collaborative law, whenever the need arises. It's, precisely in Brazil and other countries as well. Thank you.
Thank you for this opportunity, and I like to collaborate. It is a pleasure for me, and I'm available. Just be in touch anytime you need me.
Okay, no worries. Bye. Do have a lovely day. Cheers. Bye.
Bye.